Good day everyone. I am Abegail Tisio, the first presenter of the Group 5, and I will be discussing about the Article 1828 to 1829. So, listen attentively because I'm going to discuss first the Article 1828. In Article 1828, the dissolution of a partnership is the change in the relation of the partners caused by any partner choosing to be associated in the carrying on as distinguished from the winding up of the business. In other words, a dissolution of a partnership generally occurs when one of the partners chooses to be a partner in the firm. Dissolution is distinct from the termination of a partnership and the winding up of partnership business, although the term dissolution implies termination. Dissolution is actually the beginning of the process that ultimately terminates a partnership. It is, in essence, a change in the relationship between the partners. Accordingly, if a partner resigns or if a partnership expels a partner, the partnership is considered legally dissolved. Other causes of dissolution are the bankruptcy or death of a partner, an agreement of all partners to dissolve, or an event that makes the partnership business illegal. For instance, if a partnership operates a gambling casino and gambling subsequently becomes illegal, the partnership will be considered legally dissolved. In addition, a partner may withdraw from the partnership and thereby cause a dissolution. If, however, the partner withdraws in violation of a partnership agreement, the partner may be liable for damages as a result of the untimely or unauthorized withdrawal. That's all for Article 1828. The next one is Article 1829. In Article 1829, on dissolution, the partnership is not terminated but continues until the winding up of partnership affairs is completed. The principal significance of dissolution is no new partnership business should be undertaken, but affairs should be liquidated and distribution made to those entitled to the partner's interest. The term dissolution designates the point in time when the partners choose to carry on the business together. There can be several reasons for the dissolution of a partnership which mentioned below: death of a partner, admission of new partner, and early retirement of a partner. The term termination is the point in time when all partnership affairs are wound up. Also, it signifies the end of the partnership life. A partnership may terminate prematurely due to unexpected circumstances, such as the death of a partner or due to an illegal violation. Winding up is the process of settling partnership affairs after dissolution. The partners can petition to wind up the partnership but not issue bankruptcy petitions against the individual partners, or the other partners can issue a petition to wind up the partnership currently with a bankruptcy petition against the individual partners. We should not be confused in these terms because they are distinct terms in law.
Article 1830. Dissolution is caused, first, without violation of the agreement between the partners. One of the form of dissolution without violation of the agreement is termination of the definite term. This means that, example, the said date of the agreement is December 27, 2021 will be the end of a partnership. Automatically, the partnership will be terminated or dissolved. Second, in contravention of partnership agreement. One of the causes of contravention in agreement is dissolution may be for any cause or reason. This means that without finishing or reaching the fixed term of as provided in partnership agreement, it is called contravention. Example, Partner A decided to end your agreement on November 27, 2021. The term of dissolution is December 27, 2021. It is a contravention of agreement. The third one is an event which makes the business of the partnership unlawful. This means that when you start a business and the product you are selling is banned, your business became illegal, so it is unlawful. Example, you and your friends became partners and start a business. Your business is selling beef. Suddenly, the city council enacted a law or ordinance prohibiting the selling of beef and was approved. Automatically, your partnership will be dissolved because your business became unlawful. Fourth, loss of a specific thing which a partner had promised to contribute to the partnership. One of the form of loss of a specific thing is a loss before delivery. When the loss of object or a partnership contract of a specific thing, it will dissolve the partnership because it is an object of a contract.
Number 5. By the death of any partner. So in this case, there will be an automatic dissolution as well as a change in relationship. Example of this one was when Jay, who dies in September, was a minority partner in Q partnership. The distributive share of partnership income to Jay's interest through the date of death was still the same because of some provisions agreed by both partners. Number 6. By the insolvency of any partnership. Insolvency means failure. So partnership insolvents means that they are not capable with that remaining partnership properties and the partners will now take over and settle liable accounts. And the example of this one is when a person or business is unable to pay their debts. This may lead to various situations that create a poor cash flow to the business. Number 7. By the civil interdiction of any partner. Interdiction means ban or prohibited. So in this case, you cannot easily dispose nor donate the property because you lose your authority in managing the business. For example, when you are proven guilty in not pursuing your responsibilities in the business and they find out that you are into drugs while managing the business. Number 8. By decree of court under the following article. This means that under these articles, we observe the general provision that deals with different citations in order to administer all the relevant probability of the fact in the issue.
Reynolds Philippine Corporation versus Court of Appeals, GR number 36187, January 17, 1989. Upon the effect of the withdrawal before expiration of the term under Article 1830, one member causes a dissolution by expressly withdrawing before the said expiration period, with or without justifiable cause. But even if it is not justified, still the withdrawing partner is liable for damages and cannot be compelled to remain inside the firm. Due to his action, the number of members decreased. Therefore, the dissolution, in that case it was concluded that the partners were guided in the liquidation of the partnership by the provision by its duly registered article of partnership.
Article 1831. This article speaks of the grounds for dissolution by decree of court. In a suit for dissolution, proof as to the existence of the firm must be given. This Article 1831, it's need the decision of the court to dissolve the partnership in the end. So who may sue for dissolution? A partner for any of the 6 instances given in the first paragraph. So first is that a partner has been declared insane in any judicial proceeding or is shown to be unsound mind. So even if a partner has not yet been previously declared insane by the court, dissolution may be asked as long as the insanity is duly proved in court. Insanity is a cause since the partner will be incapacitated to contract. A partner becomes in any other way incapable of performing his part of the partnership contract. It may happen when the partner enters the government service, which would prohibit him from the participating in the firm, or when he will stay abroad for a long time. In the second paragraph, another who may petition for dissolution is the purchaser of a partner's interest in the partnership under Article 1813 or Article 1814. So provided that the period has expired or if the firm was a partnership at will when the interest was assigned or charged. For example, A, B, and C form a partnership to continue for a term of 5 years. On the third year, C sold his entire interest to D. Under Article 1813, such conveyance does not dissolve the partnership, and D does not become a partner, his only right being to receive the profits to which C would otherwise be entitled. Hence, D cannot ask for judicial dissolution of the partnership. However, if after the 5th year the partnership is continued, D is entitled to ask for judicial dissolution. The partnership as continued may or may not be a partnership at will. Article 1832 talks about the dissolution terminates all authority except if the partnership went out for unfinished business, except so far as may be necessary to wind up a partnership affairs or to complete transaction begun but not then finished. Dissolution terminates all authority of any partner to act for the partnership. Kapag daw in the process of dissolution na ang partnership, the only thing can be done is to complete the transaction na nasimulan na before mag-dissolve. With respect to the partners, as the partners concerned with the dissolution is not by the act, insolvency, or death of a partner, the authority to bind another transaction is immediately terminated. When the dissolution is by act, insolvency, or death, termination of authority will depend on the knowledge or notice of the dissolution. With respect to person not of partners, as declared in Article 1834, without the knowledge of termination of authority, the innocent partner can recover from the acting partner. We have here an example. A, B, and C form a partnership. If today the partnership is dissolved, then any of the partner must not enter into contract, because it is no longer binding the partnership. It said here, as a rule, when a partnership is dissolved, any of the partner cannot bind the partnership, pera na lang if the transaction is for the purpose of the liquidation. Basically, ang sinasabi lang ng 1832, after the dissolution of the partnership, ang kailangan mo lang gawin is to wind up the affairs settlement of the account and complete any unfinished transaction that was started before the dissolution.
In Article 1833, where the dissolution is caused by the act, death, or insolvency of a partner, each partner is liable to his co-partners for his share of any liability created by any partner acting for the partnership as if the partnership had not been dissolved unless 1. The dissolution being by act of any partner, the partner acting for the partnership had knowledge of the dissolution, or 2. The dissolution being by the death or insolvency of a partner. The partner acting for the partnership had knowledge or notice of the death or insolvency. Example, Mr. Marvin and Ms. Dinshaw are partners in a business called Gulays Gulayan. Each partner is responsible to his or her partner for his or her share of any responsibility to create anyone who helps in their business partnership. That's all.
Article 1834. After dissolution, a partner can bind a partnership except as provided in the third paragraph of this article. Partners may still bind a partnership to transaction even after dissolution if the transaction are with respect to the winding up or the completion of unfinished transaction. The transaction will be binding if had extended credit to the partnership prior to dissolution and had no knowledge or notice of the dissolution. Credit was extended without knowledge of the dissolution before the dissolution, or true he had not so extended credit. No credit was extended but there was knowledge of the partnership existence and none of the dissolution. The partnership is required to have the dissolution be announced in general circulation newspaper of the place of operation. As long as they do this, then it is sufficient notice to all third persons. Next, liabilities shall be satisfied out of partnership assets alone if the partner being dealt with is a dormant partner. Next paragraph is, the partnership is in no case bound by any act of a partner after dissolution. Upon dissolution, the partnership is no longer bound by transaction. First, when it becomes unlawful to carry on the business. Second, insolvency of a partner. Third, unauthorized winding up except when credit was extended and there was no knowledge of the lack of authority, and no credit was extended and there was no knowledge of the dissolution because there was no advertisement of such.
Marvin and Densha are related to a business gulays-gulayan, but Marvin is not fulfilling his role in the partnership. So Densha has written a letter that if they continue their partnership, that is what Marvin will accomplish the business partnership well and will be able to do what is right according to this article.
Article 1835. The dissolution of the partnership does not of itself discharge the existing liability of any partner. A partner is discharged from any existing liability upon dissolution of the partnership by an agreement to that effect between himself, the partnership, creditor, and person or partnership continuing the business, and such agreement may be inferred the course of dealing between the creditor having knowledge of the dissolution and the person or partnership continuing the business. So, where a person agrees to assume the existing obligations of a dissolved partnership, the partners whose obligations have been assumed shall be discharged from any liability to any creditor of the partnership who, knowing of the agreements, consents to a material alteration in the nature or time of payment of such obligations. The individual property of a deceased partner shall be liable for all obligations of the partnership incurred while he was a partner, but subject to the prior payment of his separate debts. Case sample: Marcos and Maria has a business partnership, while Maria died because of the car accident. So Mr. Marcos will have to pay as long as he lives to fulfill the deal they leave behind to pay off the remaining debt. General rule: dissolution of a partnership does not itself discharge the existing liability of any partner. Exception: a partner can be discharged from any existing upon dissolution of the partnership, provided that there is an agreement between the partnership creditor and the person or partners continuing the business.
Article 1836. Unless otherwise agreed, the partners who have not wrongfully dissolved the partnership or the legal representative of the last surviving partner not insolvent has the right to wind up the partnership affairs provided, however, that any partner, his legal representative, or his assigned upon caution may obtain winding up the court. Who may wind up partnership affairs? Partner designated in the agreement. In absence of agreement, the part that did not wrongfully dissolve the partnership. If all partners died, the legal representative of the last surviving partner, provided that the partner is not insolvent. Winding up of a dissolved partnership may be done extrajudicially by the partners themselves. Judicially, under the control of competent court, managing partner or winding up partner has the right to sell firm property even after the life of the partnership has expired.
Article 1837. When dissolution is caused in any way except in contravention of the partnership agreement, each partner, as against his co-partners and all persons claiming through them in respect of their interest in the partnership, unless otherwise agreed, may have the partnership property applied to discharge its liabilities, and the surplus applied to pay in cash the net amount owing to the prospective partners. But if dissolution is caused by expulsion of a partner bona fide under the partnership agreement, and if the expelled partner is discharged from all partnership liabilities, either by payment or agreement, under the second paragraph of Article 1835, he shall receive in cash only the net amount due him from the partnership. When dissolution is caused by the expulsion of a partner bona fide, in good faith under the partnership agreement, such as expelled partner may be discharged from all partnership liabilities by payment in cash the net amount due him from the partnership, or agreement between him, the partnership creditors, and the other partners. Article 1838. Where a partnership contract is rescinded on the ground of the fraud or misrepresentation of one of the parties thereto, the party entitled to rescind is without prejudice to any other right entitled. So the contract of partnership is voidable or annulable if one is induced by fraud or misrepresentation to become a partner. Right of lien or retention. To a lien or right of retention, the surplus of the partnership liabilities to third person for any sum of money paid by him for the purchase of an interest in the partnership and for any capital or advances contributed by him.
Article 1839. In setting accounts between the partners after dissolution, the following rules shall be observed subject to any agreement to the contrary. 1. The assets of the partnership are the partnership property, the contributions of the partners necessary for the payment of all the liabilities. 2. The liabilities of the partnership shall rank in order of payment as follows: those owing to creditors other than partners, those owing to partners other than for capital and profits, those owing to partners in respect of capital, those owing to partners in respect of profits. Number 3. When any partner retires or dies and the business of the dissolved partnership is continued as set forth in number 1 and 2 of this article. Number 4. The partners shall contribute as what Article 1797 states in regards of the amounts agreed on. As what Article 1797 stated, losses and profits shall be distributed in accordance to the said agreement. Therefore, the amount agreed on shall be contributed to the partners. 5. Assigned for the benefit of the creditors has the right to enforce the contribution in preceding numbers. ABC, who is specialized in liquidating insolvent business, grants the right to enforce the contribution of partners. In times of uncertainty, ABC will guide and will make a move to liquidate your assets and pay off your creditors. 6. Partners shall have the right to enforce contribution as per number 4 is stated if he had paid in excess of his share in liability. In this case, partner who is not in favor Article 1797 agreement, he or she must pay the excess of his share in liability. This said, partner will be given a right to enforce his/her contribution. 7. Property of deceased partner is liable for the contribution which is specified in number 4. As what I have said in number 4 in regard to Article 1797, properties of partners is liable for the contribution and will be distributed accordingly. 8. Partnership creditor will manage partnership property and separate creditors on individual property, saving the right of lien or secured creditors. Partnership property and individual property will be distributed separately. Partnership creditor will be the one who manage it. 9. Separating property when a partner is insolvent, it must rank in the following orders. A. Those owing to separate creditors. B. Those owing creditors. C. Those owing to partners by way of contribution. If the partner is unable to pay debts, he or she can separate properties but must have ranked the following orders.
These are the rules for settling accounts between the partners. 1. The assets of the partnership. 2. Liabilities of the partnership. 3. Application of assets. 4. Contribution by the partners' assets of the partnership. Under of contribution by the partners' assets of the partnership are partnership property and the contributions of the partners necessary for the payment of all liabilities, order of application of the assets. Those owing to partnership creditors and those owing to partners other than for capital and profits such as loans given by the partners or advances for business expenses are under of the contributions of the partners necessary for the payment of all liabilities and order of application of the assets.
Those owing for the return of the capital contributed by the partners, the share of the profits, if any, due to each partner, order of application of partner who become insolvent, or his estate is insolvent, the claims against his separate property. Those owing to separate creditors, those owing to partnership creditors, those owing to partners by way of contribution, law on business, organizations, reviewer, liability of deceased partners, individual property. The individual property of a deceased partner shall be liable for his share of the contributions necessary to satisfy the liabilities of the partnership incurred while he was a partner.
Article 1840. In the following cases, creditors of the dissolved partnership are also creditors of the person or partnership continuing the business. Number 1. When any new partner is admitted into an existing partnership, or when any partner retires and assigns, or the representative of the deceased partner assigns his right and partnership property to two or more of the partners, or to one or more of the partners and one or more third persons if the business is continued without liquidation of the partnership affairs. Second, when all but one partner retire and assign, or the representative of deceased partner assigns their rights and partnership property to the remaining partner, who continues the business without liquidation of partnership affairs, either alone or with others. Number 3. When any new partner retires or dies and the business of the dissolved partnership is continued, as set forth in numbers 1 and 2 of this article, with the consent of the retired partners or the representative of the deceased partner, but without any assignment of his right is partnership property. Number 4. When all the partner or their representatives assign their rights and the partnership property to one or more third persons who promise to pay the debts and who continue the business of the dissolved partnership. Number 5. When any partner wrongfully causes a dissolution and the remaining partners continue the business under the provision of Article 1837, second paragraph number 2, either alone or with others, and without liquidation of the partnership affairs. Number 6. When a partner is expelled and the remaining partners continue the business, either alone or with others, without liquidation of the partnership affairs.
The liability of the third person becoming a partner in the partnership continuing the business under this article to the creditors of the dissolved partnership shall be satisfied out of the partnership's property only, unless there is a stipulation to the contrary. The use by the person or partnership continuing the business of the partnership name or the name of a deceased partner as part thereof shall not of itself make the individual property of the deceased partner liable for any debts contracted by such person or partnership. As we know that dissolution is all about the change in relationship between partners, so basically this article talks about the partner's dissolution of partnership even though it dissolves and the business still continues, but there is no liquidation and termination happens. After an old partnership was dissolved, a new partnership was formed to continue the business as a third person, as discussed in the previous article all about the newly admitted partners' rights, liabilities, and obligations. So here are some causes of the dissolution of a partnership by change of members. Number 1 is when new partner is admitted. 2. When partner retires. 3. When partner dies. 4. When partner withdraws. 5. When partner expelled from partnership. 6. Other partners assign their rights to sole remaining partner. And 7. All the partners assign their rights in partnership property to third persons. In this case, what causes the dissolution of the business change in membership of the partnership, but still the business continues to operate? It can be turned into a sole proprietorship or corporation if there will be no replacement or the third person to the said partner. But like what I have said, the business still continues to operate even though there are changes in the relationship. But in this case, the rights of an old partner carries over by a new partner, and with that, they were still treated equally by the creditors because of the maintaining the preferential right of the old creditors to the partnership's property.